Government of India shall have absolute power to retire a public servant, that is the civil servant, in the interest of public after he reaches the age of 55 or after he completes certain years of service, that is 25 years of service. This provision also makes it mandatory that while compulsorily retiring such a public servant or civil servant, the government will have to give a notice of 3 months or salary or the emoluments for the month of for 3 months in lieu of notice. Now this 56J has been copied by almost all other public undertakings, so there may be analogous provisions in their respective CDA rules, which also empowers the concerned competent authority of the PSU or the public undertaking or any other corporate to retire its employee in the interest of public after he crosses certain years of age, that is normally 55, and in some cases some rules also incorporated that even after reaching age of 50 the authority concerned will have absolute power to retire that employee in the interest of public. In such cases also the rules mandate that notice of 3 months has to be given, or in lieu of notice salary for 3 months will have to be given. Now in such cases the departmental inquiry or the disciplinary proceedings are not held to retire. This is also called as premature retirement. Similarly, government of India also has the power to retire somebody, and that power is coming from or stemming from Article 310, that is called the Doctrine of Pleasure, because that Article 310 incorporates the doctrine of pleasure. That means as long as the government is pleased to keep you in the employment, you are entitled, and the moment you cross certain age, that is as laid down in the rules, the government is not pleased to continue, and therefore the government will retire you. Similarly, even public servant is also entitled to put in his paper after crossing particular years of service or particular age, that is called voluntary retirement. Now in short, the government has also power to retire you, and you also have a power to voluntarily take retirement. Now in such cases, because it is not the case of departmental inquiry, here you are not charge sheeted, you are not accused of having committed any misconduct, and therefore you cannot challenge such an order of compulsory retirement on the normal grounds that are raised in cases where you are dismissed or removed after holding departmental inquiry. So the scope to interfere in such matters becomes very minimal. In departmental cases, you have a lot of grounds to attack the penalty order, such as violation of principles of natural justice, non following mandatory provisions, defective procedure, incompetent authority, and non supply of documents, etc. etc. That the misconduct as alleged is not actually the misconduct. So there are several grounds, as we have discussed in earlier ways, so many videos which are available on my channel. Today we are dealing with such a case where you are compulsorily retired. Now you have to understand the basic difference between the penalty as a compulsory retirement and the premature retirement. Even after concluding the departmental inquiry, the department can impose a major penalty of compulsory retirement from service. Now this penalty as a compulsory retirement from service is always after holding department inquiry, where you are charge sheeted, where certain allegations are leveled that you committed misconduct, and then after the inquiry is held, charges are proved, the management or the employer can impose that penalty. Now this kind of penalty is distinct and different from the premature retirement, where government is considering you that you are a dead wood and to continue you in the service because you are not efficient in working or discharging your duties because of the age or because of the long service that you have already rendered, and therefore government may exercise such power to compulsorily retire you. Then what remains to be challenged? If there is such a minimal scope to interfere, and courts normally refuse to interfere in such matters, and there are very less opportunity of success in such matters when you challenge such kind of compulsory retirement as a premature retirement, that is under the provisions of 56J or other provisions analogous to fundamental rule 56J. So dear friends, in such case the long settled principle of law is that here, because inquiry is not held, you cannot make complaint of violation of natural justice directly, but still you can defend on the ground of violation of principles of natural justice. That is how. Let us consider. Sometimes what happens, there may be allegations against you casting aspersion on your integrity, your devotion, but government considers why to hold inquiry, why to go in all such lengthy process of departmental inquiry, it may take long time, and therefore in order to give a cut short to the procedure of inquiry, government will simply issue such an order of compulsory retirement from you. So here the background in which you are retired, you are given premature retirement, will have to be examined by the court when you make such a complaint. And Supreme Court of India has time and again saying that when government servant makes such a complaint, when he challenges such an order, that it is actually a punitive order or penal order, or it is stigmatic. Now we have to understand here as to what constitutes punitive order or penal order. Now such order of premature retirement should not state in the order that because of so and so misconduct, because of lack of integrity, because of your failure to devotion to duty. If order incorporates any such statement that casts aspersion on your integrity, that amounts to stigmatic order, that amounts to actually penalty, punitive order, penal order, and therefore you can say that the order of compulsory retirement or premature retirement is in fact a penalty given to you, and for that they have not followed the procedure of holding departmental inquiry. Therefore in such cases it constitutes violation of principle of natural justice. Recently Supreme Court of India has decided one such case in the case of one Captain Pramod Kumar versus CBDT. That is also reported recently by the Live Law, that is a legal website which gives you access to judgments of Supreme Court and High Courts of recent decisions. Now that judgment has referred to so many old decisions on the same subject, it has scanned so many judgments on the same subject, and from this judgment in the case of Captain Pramod Kumar, it is reiterated that when employee makes a complaint that he has actually been punished because of certain misconduct, but in order to give a cut short to the inquiry, to lengthy procedure of inquiry, the government has exercised this power, and that literally amounts to violating the right available under Article 311 of the Indian Constitution, which mandates that the inquiry is must, the compliance of natural justice is must before you punish somebody. So this is, dear friends, one such ground. Secondly, in some cases what happens, the government doesn't comply with the requirement of giving notice of 3 months or payment of 3 months salary in lieu of such notice, that also becomes a very valid ground to attack such an order, because in such cases the minimum protection that is available to the public servant is the notice of 3 months or the salary of 3 months in lieu of such notice, and when such minimal protection available to employee is also not complied with, the order should be set aside as illegal. Now these are the grounds. Now in some cases it may also happen that the authority which is incompetent to impose a penalty of removal or dismissal, or that authority that is subordinate to the appointing authority, may issue such an order. So you can also attack such an order on the ground that it has been issued by the incompetent authority, therefore on this ground also it should be quashed and set aside. Now there are office memorandums issued by the Government of India pursuant to a celebrated judgment of Supreme Court in the case of State of Gujarat versus Umed Bhai Patel, where Supreme Court has highlighted that the inquiry should not be avoided in cases where the actual intent of government is to punish the employee. Therefore the provision of 56J cannot be used as a shortcut to punish the government employee without complying with the principle of natural justice. Now in such cases, the office memorandum issued by the Government of India in the year 2015 lays down certain procedure that when employee is reaching that age as prescribed in the statute, that is, for example, the government is intending to compulsorily retire you once you attain the age of 55, then there has to be a review committee. That review committee will have how many data as to how many employees are going to attain the age of 55 in the next quarter, and all of their APRs or ACRs, that is annual confidential reports, should be considered, and the review committee will have to come to a conclusion whether it is in the fitness of things, whether it is in the interest of public to retain such employee or to compulsory retirement. Now in such cases, if such procedure is also not followed, that is without carrying out actual review, if the penalty, if the government servant is given such a premature retirement, even that also becomes a very valid and strong ground to attack such an order of the premature retirement. Now dear friends, this case, this premature retirement is like a case where some government servant who is newly entered into service, and before probation of his service, completion of probation of service, he is given termination simpliciter, that is without casting any aspersions on his personality. So in such case also government, the courts will have very minimal scope to interfere, but even in those cases also the background will have to be examined. If the employee makes a complaint or employee shows that the actual background is that is imposing punishment upon him, and because he is simply newly entrant in the service and he has not completed his probation, and therefore government exercise the power of giving him simpliciter discharge from service or termination from service without carrying out any inquiry. Now these both cases have common aspect, that is lifting of veil. Now when employee makes a complaint, that background will have to be examined, then court will have to lift the veil to see whether the government has really intended to punish him, and whether government has exercised its power to cut short the procedure and to get rid of the employee. Now in such cases, these are few of such grounds where we can attack the premature retirement. In some cases it may also happen that preceding to your premature retirement your ACRs are very good, and then government goes back in the history and takes out that 10 years ago your service, your ACR was not good, 7 years ago your ACR was not good, and considering those old ACRs, if government imposes such an order, then on that ground also the order has to be held illegal. Some cases it may happen that despite of your whatever ACR it is, you are promoted in the near preceding years, and after you are promoted you are given such a premature retirement, then also you can attack on the ground that you are promoted because you are fit, you are discharging very well, and because you are discharging your duties very well, you are promoted. So after the promotion is done, how come government can take U-turn and say that you become a deadwood? So these are few of such grounds that I have tried to discuss here, dear friends.